Hey everybody, welcome to my YouTube channel, Foreclosure Help 777. You can also join us on our Facebook page, which is also Foreclosure Help 777, where we talk about everything foreclosure related so we can help you stay in your house. Today we're going to talk about one of my friend's case. Her name is Kerri Maloney, and her case is in Florida. This is the docket. You can see the case was filed, actual complaint was filed on 10/26/23, and this is a judicial state, so they filed her a foreclosure complaint and summons, and she filed an answer with counterclaims on, let's see here, right here, 11/13. She filed her answer and counterclaims, and then the bank filed the next one, which is, it says plaintiff's reply to defendant. Okay, so they filed a reply on 11/21, and since they filed a reply, Kerri filed a response to their complaint on 12/6, which was yesterday. She filed this defendant's response to plaintiff's reply on 12/6. So let's look at those for a minute so you guys get an idea of what's going on here. The bank's reply is right here. This is what the cover looks like. Plaintiff's reply to defendants Joseph Maloney Jr. and Kerri Maloney, affirmative defenses to the complaint. They identify themselves in the first paragraph. Plaintiff U.S. Bank National Association as successor in interest to Bank of America National Association, successor by merger to LaSalle Bank National Association as trustee for Ownit Mortgage Loan Trust, Mortgage Loan Asset-Backed Certificate Series 2006-4, by and through the undersigned counsel hereby files its reply to defendants the Maloneys, affirmative defenses to the complaint, and states as follows. Now they're going to start saying that their answer and counterclaims are vague and don't have any facts, and they're saying about the affirmative defenses that they were pleading raises new matter. It says raises new matter to defeat the opposing party's otherwise apparently valid claim. Well, that is how this game is played. You have the right to file a affirmative defense in foreclosure. So now here comes a paragraph of what I call cut and paste by the bank, and you can read it here, what it says, or you can go online and look for it, or I can send it to you if you want to read it. But this is all just legal conclusions by the bank, basically talking about affirmative defenses that merely deny the allegations in a pleading and do not raise any new matter to defeat the allegations, fail the test for the sufficiency of affirmative defenses. A conclusory statement without any actual facts is a general denial and not a legally sufficient affirmative defense. In this matter, each defendant's affirmative defense fails to assert any real allegations of ultimate fact, and instead pleads only general, vague, or conclusory allegations, or otherwise assert legal conclusions. This is the way they always say on their briefs. They don't really come back with really good answers to what you're saying. So anyway, this is just vague stuff they're saying. And they're talking about here, let's see the bolded type here, as to defendant's affirmative defense relating to lack of standing to foreclosure. Plaintiff has standing to maintain this action because it has possession of the original note bearing an endorsement in blank or a specific endorsement to name plaintiff. And then they give you some case law. So they're saying they have the note, but it really doesn't matter. They claim they have the note, but I bet you anything they don't really have the note. They have a copy of a note, they have an electronic file, but they don't have the original note. It ceased to exist. We will get to that further in litigation as this keeps going back and forth. But I'm telling you, they don't have the note. Anyway, so it's saying here that they are allowed to foreclose as a matter of law. But really, truly, they are not. They cannot do that with what they have. And then they talk about, in this paragraph, additionally, plaintiff states that defendant does not have standing to raise any issues related to a trust because defendant is not a party to or a third-party beneficiary of the trust. And that gives you case law on that. It says here, because the borrowers are not parties or third-party beneficiaries to the pooling and servicing agreement, they cannot raise purported violations of the agreement to defend against foreclosure. Okay, so this is the kind of stuff they're saying. Talking about improper loan servicing, defendants assert that plaintiff has failed to properly credit their monthly payments and has been charging unauthorized fees and has induced default. Despite these conclusory allegations, defendants have failed to provide any material facts, documents, or evidence which would support this defense. Okay, so let's talk about how she's going to reply to this brief. It's pretty much about it anyway. So this is what she filed in response to that. Defendant's response to plaintiff's reply to affirmative defenses to the complaint. And then you see the first paragraph. They identify themselves. Defendants, both acting in pro se capacity, want it noted that on the date of December 5th, they contacted the plaintiff's attorney, Van Ness Law Firm, to complain that they never received a copy of the motion that they filed on November 21st. So that's another thing. If you have to check the dockets proactively to see if they even filed something, because one of the tricks they will try to pull is they'll file something and not actually send you a copy of it when they're required to. But to get around that, I wanted to make sure on the first paragraph that was noted. Anyways, let's keep going. Defendants assert that their answers and counterclaims are not vague or conclusory, but are instead based on facts. So you want to come back arguing what they said in their last motion, basically. Defendant's response to paragraph 2 on page 3. As to defendant's affirmative defense relating to lack of standing to foreclose, plaintiff has standing to maintain this action because it has possession of the original note bearing an endorsement in blank. Plaintiff may claim that it owns the original wedding promissory note. However, until the plaintiff brings the actual note to court to examine if it is authentic, it is just considered hearsay. Defendants therefore object to plaintiff's claim of having it. You have to object to everything they say and explain why, and that's the reason. And then it says on page 4, paragraph 3 of plaintiff's reply brief, plaintiff states, additionally, plaintiff states that defendant does not have standing to raise any issues related to the trust because the defendant is not a party to or a third-party beneficiary of the trust. Defendant's response is they are a party to the securitization trust. See a copy of the publication, Asset Securitization by the Office of the Comptroller of the Currency. A copy of this is attached hereto as Exhibit A. On page 11 of 92, the publication states, the borrower is responsible for the payment on the underlying loans, and therefore the ultimate performance of the asset-backed security. Because borrowers often do not realize that their loans have been sold, the originating bank is often able to maintain the customer relationship. Now that sounds pretty deceitful to me, doesn't it? But it looks like the borrower is actually a party to the trust according to this publication. So let's move on to the next. Plaintiff states on page 5 of the reply brief the following. As to defendant's affirmative defense relating to improper loan servicing, defendants assert that plaintiff has failed to properly credit the monthly payments and has charged unauthorized fees and has induced default. Despite these conclusory allegations, defendants have failed to provide any material facts, documents, or evidence which would support this defense. Now we're responding to that. To this, defendants respond by saying that a complete payment history has been requested many times, and they have not been able to provide a complete payment history. Defendants assert that they have also served discovery requests to plaintiff with copies of statements and payment history. Once defendants are given this information, it will provide more than enough evidentiary proof that they have been harmed. Defendants are entitled to discovery to substantiate their affirmative defenses. Missing endorsements on the note. Now we're going to go over that. There are still unanswered questions regarding the copy of the note that was attached to the complaint. On page 10 of the complaint shows page 3 of the note where it shows the defendant's signatures. There is enough left on that page for originating bank to stamp or endorse it, but it is blank. That by itself is suspicious. There is a separate page showing a stamp marked void on it and an allonge that is not giving ownership to a trust. The allonge states, "Pay to the order of Without Recourse Own It Mortgage Solutions, Inc. by its attorneys, in fact, Litton Loan Servicing." This is proof that it is not owned by the Own It Mortgage Asset-Backed Certificates Trust 2006-4. If the trust actually owned it or acquired the note, it would be properly endorsed from all parties according to its pooling and servicing agreement. According to the PSA, the parties must endorse the note. The parties that must endorse the note are, these are the parties that must endorse these things. The originator is Own It Mortgage Solutions. The sponsor is Merrill Lynch Mortgage Lending. The depositor is Merrill Lynch Mortgage Investors. The trustee is U.S. Bank National Association. The promissory note is not signed by Merrill Lynch Mortgage Lending. The promissory note is not signed by Merrill Lynch Mortgage Investors. The note is not signed by U.S. Bank National Association. Missing assignments of mortgage. There should be 4 separate assignments of mortgage made according to the PSA. The first assignment, the assignor, Own It Mortgage Solutions, assigns the mortgage to the assignee, sponsor, Merrill Lynch Mortgage Lending. The second assignment, the assigner, sponsor, Merrill Lynch Mortgage Lending, assigns the mortgage to the assignee, depositor, Merrill Lynch Mortgage Investors. The third assignment, the assigner, depositor, Merrill Lynch Mortgage Investors, assigns the mortgage to the assignee, the trustee, U.S. Bank National Association. The fourth assignment, the assigner, trustee, U.S. Bank National Association, assigns the mortgage to the trust, the Own It 2006-4 Asset-Backed Certificates Trust. When specially endorsed, an instrument becomes payable to the identified person and may be negotiated only by the endorsement of that person, according to Florida statute. Where a bank is seeking to enforce a note that is specially endorsed to another, the bank is a non-holder in possession, and then there's a case law attached, Murray versus HSBC Bank. Review was dismissed. A non-holder in possession may prove its right to enforce the note through 1. Evidence of an effective transfer. 2. Proof of purchase of the debt. Or 3. Evidence of a valid assignment of mortgage. See, they don't have any assignments of mortgage, so they're kind of up the creek right now. Okay, so it's saying here in this case, see Lamb versus Nation Star, a note holder in possession must account for its possession of the instrument by providing the transaction or series of transactions through which it acquired the note. Wherefore, defendants assert that the plaintiff lacks standing to foreclose and pray that the court will dismiss this case and grant relief to relief requested on defendants' counterclaims. Okay, so then that's that. Certificate of service. They have to, of course, send a copy of this to the other side, and they did. Okay, so that's that. Now, the Exhibit A, I want to show you on this. This is that publication we were talking about, asset securitization. You can Google this and find it easily. And it was published in November of '97. So it's been around a while. So let's go to the part we wanted them to look at real quick here. And I think it's a pretty important thing in case if you have to argue this in court, you'll have proof. Okay, so on page 8, it says, Exhibit 1, parties involved in structuring asset-backed securities. And you can see that the borrower is really at the top of the food chain here. So let's talk about, this is a special purpose vehicle. Okay, now you have the borrower. The borrower is responsible for payment on the underlying loans. and therefore the ultimate performance of the asset-backed security. Because borrowers often do not realize that their loans have been sold, the originating bank is often able to maintain the customer relationship. So, as you can see, the borrower is actually a party involved in this trust and can argue that they are a party, because they are, according to asset securitization, they are. Parties are straightforward here. So I thought this would be good information for you guys. If you have any questions about this, you can send me an email. My email address is foreclosurehelp777@gmail.com, or you can text me, send me a text message on my Facebook page, and I'll be happy to answer your questions. Or you can leave comments. You can leave a comment. Okay, I hope everybody has a great day.